The application that changed things potentially for many women was lodged by Mrs G. Let's delve further with her lawyer, specialist family lawyer Beverly Clark. Ms Clark, thank you for being with us. Tell us more about the case of Mrs G, presumably a name to protect her identity.
Yes, one's not allowed to report the names or identifying features of parties in divorce matters, although you can talk about the case and the law. So Mrs G was married in 1988. She was 22 years old, and she was presented with a one-page antenuptial contract just before the date of the wedding, which of course happens to many people. And in fact, her father-in-law said to her, "Nobody's marrying into my family without signing this antenuptial contract." And what the antenuptial contract said, which is quite common in South Africa, is that they would be married without out of community of property and without the accrual system. The accrual system in South Africa provides that parties will share what they have accrued during their marriage. They will share on dissolution of the marriage. If you marry without the accrual system, then what's yours is yours and what's mine is mine, and there's no sharing on dissolution of the marriage. And until this week, our courts were not allowed to interfere in that situation. If the technicality is if you were married after November 1984. And but if you were married before November 1984, the court can, in appropriate circumstances, order a redistribution of assets. So Mrs G went to court to say this is unfair discrimination in terms of our constitution, because it's irrational that if she'd been married just 4 years earlier, she could have claimed a redistribution of assets. And what Judge Elmarie van der Schaiff in Pretoria held this week was that time bar in the Divorce Act is unconstitutional and infringes on people's fundamental human rights and dignity. So now anybody who is married with an antenuptial contract after November 1984 or before, which was always the case, which excludes accrual, can go to the court and say, I have made contributions during my marriage of any variety in the home, raising children, and I am therefore entitled to a portion of the assets of my spouse.
So I've mistakenly believed that almost everybody did the accrual system because it protects both parties, but you're saying that this would actually impact on a vast swath of women in our country.
Yeah, it would. And certainly less so now, but in the 1980s, the 90s, many women didn't work outside the home and became economically disadvantaged, even if they perhaps took time off to raise children. And the other party, or the husband usually, would be the one who became wealthier during the marriage or had more money. And many women who have these kind of antenuptial contracts simply had no claim. And there has been a great deal of injustice perpetrated as a result of this portion of the Divorce Act for many, many years. So it's incredibly exciting to us that is no longer going to be the case.
It's often said that a monetary value should be put on homework, housework and childcare, because it isn't free labour in the sense that the women are sacrificing doing other things. Does this open up claims, I'm interested, even from stay-at-home husbands?
Absolutely. No, absolutely it does. And there's a long line of cases which relate to pre-1984 marriages, where our courts have held that work in the home and in the child-rearing sphere does have a value and is entitled to compensation. So that is not new. It's just that previously it applied only to people married before 1984, and now it applies to people who are still married.
Okay, so it was just a block in terms of time. This, I understand, does have to go to the Constitutional Court before the law actually changes. Are you confident the ruling will stand?
I really am confident. It is quite possible that people could come as what we call friends of the court and could seek to dissuade the Constitutional Court, but the Minister of Justice agreed with us that it is high time that this law was changed. So initially the Minister of Justice opposed our application, and then he withdrew his opposition, and he agreed that there was in fact an urgent need to change this legislation. So yes, I am confident, Francis.
And finally, just out of interest, what is the position of Mrs G? Does she have to postpone her divorce until the whole legal process is over?
Yes, and that is what happened. We got an order by the court to stay the divorce, to hold it in abeyance pending the outcome of this standalone application. And now that we have completed this application, and once we have confirmation from the Constitutional Court, then the divorce itself can continue. And then, of course, she would have to prove the facts to show that she did, in fact, make a contribution during the marriage. And so, for instance, she raised 3 children. She was very, very involved in the home, the community, the farm. And it'll be open to her husband in the divorce proceedings to try to prove, if he so wishes, that she didn't make a contribution worthy of compensation during those 35 years.
All right, fascinating. Thank you very much, and congratulations on a very important ruling, Specialist Family Lawyer Beverly Clark.